Hey guys, today we are going to discuss about public prosecutor. The provision of public prosecutor is given under section 2 subsection U, section 24 and section 25 of the Code of Criminal Procedure 1973. Section 2 subsection U of the Code of Criminal Procedure defines public prosecutor. It says any person who is appointed under section 24 is a public prosecutor, and any person working under the direction of a public prosecutor is also a public prosecutor. This definition of public prosecutor doesn't clarify what is public prosecutor. In a welfare society, state is the protector of the society. If any offense is committed against any individual, it not only affected that victim, but it also affected the whole society at large. Under these circumstances, state comes to protect the victim and prosecutes against the offender. To prosecute against the accused, state government appoints a person, and that person is the public prosecutor. In the case of Ram Ranjan Roy, the court held that the purpose of a criminal trial is to investigate the offense and to determine the guilt or the innocence of the accused. The public prosecutor does not represent the police but the state. Therefore, he must discharge his duties fairly, fearlessly, and with full sense of responsibility. It doesn't mean that a public prosecutor is the agent of police or the agent of the state, but a public prosecutor is the sole agent of justice. Subscribe the channel and hit the bell to not miss any update. Section 24 says a lot about public prosecutor. Subsection 1 of section 24 says that for every high court, the state government or the central government, after consulting that high court, must appoint a public prosecutor and may also appoint one or more additional public prosecutor for conducting trial, appeals, and to deal with any matter in the court on behalf of the state. Subsection 2 of section 24 says that the central government may appoint one or more public prosecutor to deal with any case or any class of cases in any district or in any local area. The state government is to appoint one or more additional public prosecutor for every district, provided also that a public prosecutor or an additional public prosecutor can be appointed as an public prosecutor or an additional public prosecutor for another district. Subsection 4 of section 25 says about who are to be appointed public prosecutor. It says that the district magistrate, after consulting the session judge, is to prepare a panel of names who are, in the opinion of the district magistrate, are fit to be appointed as the public prosecutor or an additional public prosecutor for the district. Subsection 5 of section 25 says that no person can be appointed as an additional public prosecutor or a public prosecutor if his or her name is not in the panel of names prepared by the district magistrate after consulting the session judge, in accordance with the provision of subsection 4. Subsection 6 of section 25 says that where in a state there exists a regular cadre of prosecuting officer, then the state government must appoint public prosecutor or additional public prosecutor only from the regular cadre of prosecuting officers. provided that if the state government finds that no suitable person is available in the regular cadre of prosecuting officers, then the state government can appoint any person whose name is in the panel of names prepared by the district magistrate. Subsection 7 of section 25 says that a person can be appointed as a public prosecutor or an additional public prosecutor if he is an advocate practicing for at least 7 years. Subsection 8, section 25 says that the state government or the central government is to appoint special public prosecutor to deal with any case or any class of cases, and to be appointed as a special public prosecutor, an advocate must be practicing law for at least 10 years. Subsection 9 of section 24 says that if an advocate has served as a public prosecutor or an additional public prosecutor, then the period for which that person served as public prosecutor or additional public prosecutor will be added into his career as a practicing advocate. Suppose an advocate has 7 years of experience as a practicing advocate and thus become eligible to be appointed as public prosecutor or additional public prosecutor. Suppose that advocate has been appointed as an additional public prosecutor for 3 years. He had been practicing as an advocate for 7 years, and after the completion of the term of additional public prosecutor of his 3 years, then he will be regarded as an advocate practicing for a term 10 years. Then he will be eligible to be appointed as special public prosecutor. Section 25 says about assistant public prosecutor. Subsection 1 says that for every district, the state government is to appoint one or more assistant public prosecutor for conducting its prosecution in a court of magistrate. Subsection 1A of section 25 says that the central government may appoint one or more assistant public prosecutor to deal with any case or any class of cases in a court of magistrate. Subsection 2 of section 25 says that no police officer can be appointed as assistant public prosecutor other than the way mentioned in subsection 3. It means that following the procedure provided in subsection 3, a police officer can also be appointed as an assistant public prosecutor. Subsection 3 says that when no suitable person is available to be appointed as assistant public prosecutor, then the district magistrate can appoint any person who is in charge of the case as an assistant public prosecutor. Subsection 3 has two provisions. Firstly, it is said that a police officer cannot be appointed as an assistant public prosecutor if that police officer has taken part in the investigation of the case where the accused has been prosecuted, and B, a police officer below the rank of inspector cannot be appointed as an assistant public prosecutor. Thank you so much. I hope you liked the video. If you have any doubts, do let me know and I'll try the best possible way to clear those doubts